preventing the MS patient and a lot of other people who actually need the edibles that Michele is going to be, another medicine that Michele is going to be talking about. So raises some fascinating questions about what should be the best practices and how to deal with it in a way that makes logical sense.
Thank you. A little bit about me. When I first graduated law school, I worked for legal aid in Texas. And I worked there for 9 years, did a lot of family law, a lot of social change because we were advocating for poor people and, you know, people who were facing various obstacles. And what I have found so far with the marijuana and parenting custody issues is that there are 3 areas where it can come up. It can come up in criminal cases like Michael was just talking about, and I don't deal with the criminal defense cases, but those are potentially the most serious. Second, they can come up in CPS cases. And I'll call it CPS even though they're different agencies in every different state, but it's Child Protective Services, and it's where the state comes in and says, you're not fit to be a parent, we're going to take your rights away. And then the final place that it can come up is just in a family law case between parents, just a regular child custody situation. In Colorado, that does not happen very much at all. That within a regular custody case, just the use or possession of marijuana becomes an issue that they ask the judge to consider. In the criminal defense cases and in the CPS cases, yes, it does. So I wanted to review the law very, very briefly. Then I want to play you a little clip of the most recent NPR interview this past Thursday from a doctor at Children's Hospital in Aurora talking about edibles in this study that he's done that's going to be published in the Journal of Pediatric Medicine by the AMA. And then I want to spend the most time on the social change that it is our responsibility to do, to help our clients do, to help patients do, to help consumers do, and then lead the charge ever forward. How do I make this go up and down?
Space bar should do it.
Okay, so what is child abuse? And again, there are the 2 tracks. There are the CPS cases, which are civil statutes, and then there are the criminal statutes that are basically the DA's office. So the most evolved view, and we're seeing this come more and more often, is that use alone isn't enough. In addition to the use, you've got to show some sort of an endangerment to the child. In other places, use is illegal, that's it. Texas, my beloved teacher of how to litigate state, in the CPS cases, the state can terminate the parental rights if the parents endanger the physical or emotional well-being of the child. So you can see civil litigators love this, physical and emotional well-being of the child. You look at the surroundings, this is where Michael said you get down to the facts. This is where the best practices that parents are going to develop are going to be brought in to say, well, you did this, you had your prescriptions locked away, they couldn't get to them, your grow room was completely inaccessible, you had it checked for mold, you know, whatever the standards are that we begin to develop. But look here, under the criminal statutes in Texas, there is a presumption that a parent places the child in danger simply if they use a Schedule I controlled substance when they don't have ability to do so. So that last phrase, even though in Texas marijuana is not legal in any way, what if this statute were adopted in another state where if it is legal to do so? For example, in Colorado right now, would this statute protect, under the criminal code, a marijuana user since it is now legal in marijuana to use and consume? So I think there are some good cases to be litigated. In Colorado, the CPS cases, it's neglected or dependent when the child's environment is injurious. So we get back to the physical environment again. And then there is not an equivalent for the criminal consequences, just the use, but it is a crime if a controlled substance is manufactured where a child lives. And so I'm not going to get into all the details of manufacture. There's some case law in Colorado that's good. That talks about it's highly individualized, we have to look at these facts. If the sole basis is the use of marijuana, you got to have something else that shows that there's a threat to the emotional health or safety. What they looked at is, the father used marijuana while the children were at home, so there was there was a risk of smoke inhalation. Consider if a child has asthma. We need to be very realistic about what these risks are and what people are going to say and get the sympathy of them. So it's very easy to have it be a practice in your home that you do not ingest marijuana by smoking it when your children are present and around. I think that's a reasonable accommodation that we can make, and I think we gain a lot of ground if we make that accommodation and encourage people to do that. The mood stuff, this is going to get me to the mental health issue. You know, we don't yet have great studies about what the impact of marijuana is on people's moods. It changes from strain to strain, from person to person, and we just do not have enough information at this point to make a conclusive statement one way or the other, and so that's the attack that we have to make there. Habitual use, substance abuse. This is again where the court systems go to the mental health experts. We have got to get the mental health experts on our side in terms of understanding the actual effects of marijuana, not the stigmatic effects of marijuana, not the mythological effects of marijuana, but the actual ones. So substance abuse and adequate supervision. And so you see the adequate supervision kind of plays into the, oh, you're stoned and spacing out idea. DSM, this is horrible. So know your symptoms of abuse for DSM and be ready to counteract them, but you're gonna have to have a mental health professional help you do this. Adequate, no food, no water, etc. And I know I'm speeding through this, but I really want to get to the conversation part. So toddlers reach, when kids can get it. Let me play this clip. And again, this is Dr. Wang from the Children's Hospital.
Legal, and as more states legalize it, I think it's something we all need to keep in mind.
So we talked about in our introduction that kids were having trouble breathing and walking as a result of exposure. What else?
Yeah, so like with any other exposure, the symptoms are a kind of a spectrum of effect depending on how big or small the child is or how much they got into. So some kids came in just a little drowsy, a little tired, but then smaller kids who got into a larger amount actually became more sleepy, difficult to arouse. They couldn't walk right because they were so unbalanced, and to the extreme case, they were so sleepy that they had difficulties breathing and had to go to the intensive care unit to be watched.
What is the age range of kids brought in who wound up testing positive, I guess, for marijuana?
Yeah, those 14 kids, the age range was as young as 8 months and as old as 12 years. The majority were kind of in the toddler, 1 to 3, 4-year age group, which is what we typically see at the poisoning center as far as unintentional pediatric ingestions. This is the time where they're getting around, exploring.
And putting it in their mouths.
Exactly. Unintentionally eating and drinking things.
When you looked back at these cases, because what you did was a kind of file review, was it noted the circumstances of the ingestion? In other words, mom or dad left something out?
Yeah.
Or, did you have some sense of why the exposure happened?
Some of the cases we did, but for the most part we were limited to what was in the hospital chart. And a lot of, actually the majority of the time, kids came in with the symptoms. So parents said very difficult to arouse, or they're not walking straight, or they're acting odd, or acting funny. And so,
for the most part, it sounds like the parents were ignorant as to what happened.
Exactly.
Okay.
And so then the emergency room physician, seeing a child like that, they have to start doing a battery of tests to figure out why they were acting that way.
Did it ever happen that a parent came in and said, oh, they got in the brain?
Yes, there was a couple of cases where the kids ate a cookie and they were like, oh no, we know this is medical marijuana cookie. We were going to bring them in to see if we need to do anything.
Do we get into child endangerment issues here, where doctors need to alert the authorities and all, or is this just seen as an unfortunate accident, like the kid got into, Roundup weed killer by accident?
Yeah, that's a good question. I think some of them were concerned about the well-being of the children, and others were, truly accidental. I think,
and the whole line between like a healthy household and a drug-endangered household, it's a fuzzy line.
Right, especially with medical marijuana. I think there's a fuzzy line in that, if a child gets into grandma's medication, no one really has a concern. But with this kind of new age we're living in with medical marijuana, I think you're right, I think there's a fuzzy line.
Sounds like it's one you're still navigating yourself.
Absolutely.
All right, let's leave us with fuzzy lines. So what did you guys hear in there as a lawyer that was noteworthy, either in terms of you're representing somebody in trial with one of these things? I mean, what does that teach you about where the medical profession is coming from? Yes?
I don't know about what it teaches me about that, but this particular doctor seemed to indicate that, hey, if the kid gets into grandma's Vicodin, nobody seems to care, but if he, gets into the medical marijuana, now he might have some child endangerment issues.
Well,
so, I mean, I'm just thinking cross-examining this doctor.
Yeah, and I think that's right. And the way I looked at that in the context of the social change that we can do is normalizing marijuana in the household. Of course we have prescriptions in the household. That's normal.
Well,
it's
that's
just
the
the
conclusion
same.
I draw is the doctors apparently don't give a shit about all the prescription drugs they're handing out to people, and if the kids get into them, well, big fucking deal. But their attitude needs to change and understand that cannabis is a medicine, just like the shit they're handing out to grandma.
And then let's take that a step further. What is it that parents can do to take advantage of that situation? So what do? How do you treat your prescription drugs?
Talk to your doctor.
No, in the home.
Oh.
In the home, yes.
Keep them out of reach, keep them in child-resistant containers.
Right.
Locked up.
Child-resistant containers, keep them out of reach. Did you notice the ages of the children? The majority age group that was getting into edibles? 1 to 3, 0 to 4. So anything up high, unless they're totally climbing, they're not going to be able to reach, and that's going to be, all you can do is what you can do as a parent. Yes?
One of the things that struck me was the fact that the parents are bringing their children in and not telling the emergency room physician what happened. So they're further delaying medical treatment, where they could just go in and say, child got into the medicine, let's treat them. Instead, what the doctor described was having to go through a battery of tests to determine what happened because the parents are scared probably about what the consequences may be. But by hiding it, I think it's a lot worse for the parents.
Did everyone hear what Aaron said?
If I could follow, when I first heard this, I heard the story driving up here on Thursday, and that was my same reaction was, it's legal, why aren't the parents telling these doctors? Obviously we understand why they might not admit it, but my question is, because the child is really, the parents are acting on behalf of the child, is the parent's conversation with the child covered by doctor-patient privilege, where, it's not only best practices for the parent, but best practice for us to be able to say, look, you are the guardian of the child, that privilege runs through you, and we need to be telling the doctors so that these stories aren't all over the news.
Well, let me introduce you to the rules of privilege in family law cases. Which is basically that anything that has to do with the best interest of the child is admissible because the parties, by virtue of having to be involved in this process, have waived all privilege. There are exceptions between the child. I'm sorry?
Doctors are mandatory reporters.
And doctors are mandatory reporters. And that gets to what the next wanted to go to that feeds into this is, what did they say that they were probably going to be looking at including on the intake form? Particular questions about possession, use, how did this happen, where did it come from? If the law is unsettled about how that plays out in child abuse and child endangerment cases, then what is it that the parents are putting themselves at risk as, and how can we, as much of a community as we can be, how can we educate parents about this? And we can walk in now in Colorado and not have shame, not have fear. We have not broken state laws. And it's really important. When I deal with parents who are working with CPS, I tell them, look at the things that you have done to protect your child. And to give them the confidence that, yes, indeed, they are good parents. They know how to be good parents. That does take away a little bit the power of the state, just emotionally anyway. Hang on just a second, Sean, and sir, you had your hand raised earlier.
Well, I was just going to say, maybe I missed something, but I thought the issue still persisted as to what was really going on in all these cases. Could they really tie these observations of the children to the marijuana? And maybe they're doing blood tests, but that doesn't necessarily mean that the child is actually being psychomotorly being affected by the marijuana. So they're going, it seems to me there's a bias towards focusing on the marijuana in the absence of proof that the child has ingested it, when there may be other things going on.
Mhm. And so what you're talking about is challenging the findings and the conclusions in this report. You know, are they substantiated? You have to subscribe to get to the actual details in the report and the methodology and the results and stuff. This is from the abstract, and when I just read the results in the abstract, I am a little confused. Because, well, first of all, there were 14 total cases in a period of just 3 years, from 2009 until when they did the test. So 14. Well, it is nothing, and he says so. However, it was 0. That's the problem.
Oh.
However,
Wait, what was it?
Well, but again,
before
that-
2009, for the period they looked at their records of children's ingestions of poisons, and they identified poison. From the period before 2009, there were 0, and I'm looking for the dates on this. And then after October 1st, 2009, there were 14. So it is very small, but it has happened. You know, we do have to acknowledge that this has happened. And not only do we have to acknowledge it whether or not it's, you know, enormous, the media, the press, your common people are seeing this as an issue, common people. So if you look at the results, they don't add up. So they said 9 kids had lethargy, and that's really one of the most common symptoms that you're going to see from accidental marijuana ingestion is just, you know, extreme tiredness, sleepiness. 1 had ataxia, which is just the loss of your muscle coordination, and 1 had respiratory insufficiency. So when I get 14, I go 9, 10, 11. All right, what happened to the other 3? You know, what symptoms did they, you know, just release and go home? 8 were admitted, 2 to the intensive care unit, and what he says earlier in the story is that those are because of the difficulties with the respiration and the breathing because the muscles have relaxed so much. And then I really don't understand how 8 of the 14 involved medical marijuana. I don't know what they mean by that exactly. And then 7 of these exposures were from food products.
Do they mean herb versus edible?
No, I think
No
what they mean
idea.
is that they were patients
As
who,
opposed
the
to-
the parents were patients who had legally obtained the marijuana.
So,
That's what I
who
understood
knows?
the report.
But what's really, really interesting in, you know, for me, because this guy has gotten us a lot of stuff. You know, he's kind of on a roll with this, and it seems to be pretty, you know, reputable. So the consequences of this in children should be part of the ongoing debate. So here we are, smack dab in the middle of the ongoing debate. Sean.
I've got calls lately from people saying they tested the baby after it was born and there's some THC in the system. I don't think active THC permeates the placenta. Anybody knows that, I'd like to hear it. But, and also, I don't know if they're testing babies with just blood tests for inactive or active. But have you ever heard of any of those cases?
Yeah, absolutely.
What's the
Yeah, let me go, and I want to come back to this because these might be related. Michael?
I just had a quick question. There were 7 ingestions from food products. What were the other 7?
That's what I'm saying. I haven't been able to read the more than just the abstract.
Can you scroll up to the title? We
Yeah.
can get it.
I mean, it could have been, and I don't know what caused it. It could have been, you know, oils. I don't know, but I actually represented a doctor charged with the state medical board for recommending marijuana to a girl who turned out was pregnant and had lied to him. And there are a lot of interesting studies out of Europe where European physicians recommend marijuana to treat nausea. You know, they think that it's better that the pregnant women are eating to feed the fetus, and that the marijuana, you know, I think there's debate about whether it's actually crossing over, but the kids are testing positive. So it is getting into their system. It's not that they're exhibiting symptoms. It's not that they're presenting with anything. But generally, they're in cases where social services has been involved, or this case was the mother hadn't presented for neonatal care, prenatal care early enough in the process. This is the doctor's stated explanation. But under cross, this doctor ultimately admitted that she didn't think that there was any harm to the child, even if the child tested positive. So if you get enough studies and cross-examination, the doctors, some of them will cave.
What was the resolution in that case?
It's long and complicated because it involved a criminal, you know, writing 2 recommendations to undercover officers. So we had multiple med board matters as well as a major criminal case going on. So I'll tell you later, it's complicated, but.
And so, Sean, in response to your particular question, I have not dealt with one of those cases. The NORML Women's Alliance has taken this on as one of their special areas. The most recent case that I read had to do with the testing of a fetus. And so basically the court kind of judged the question about whether just testing and having a result of positive cannabis alone was enough, because it said a fetus wasn't a person under the law of that state, and that you had to be a person in order to be child abused or child endangered, because child is a person. So they sidestepped that. And the thing is, with these cases, first of all, the majority of people are poor. Second of all, they're scared to death, and they'll do whatever it is that they're told to do at this time. I mean, the woman has just given birth, for God's sake, you know? Yes?
A good resource on this issue is the National Advocates for Pregnant Women. They've represented women who've been charged with delivery to fetuses and other kinds of problems. In Oregon, they do test children for the blood when they're born. If it tests positive for THC, DHS shows up and gives advice, but they don't take any action, particularly as to medical marijuana mothers. I wanted to say earlier that in my dealings with CPS or DHS or whatever it is, the best advice for parents is to adopt what our friend Doug Hyatt describes the rest of the world's view of marijuana as being like kryptonite. And you have to, and while I appreciate and respect that it's not nearly as harmful as conventional pharmaceutical medications, when you make that analogy in court, they look at you like you have two heads. And what you have to do is say, not only am I keep my medicine out of reach, but I keep my medical marijuana medicine locked up in a box behind a door that's locked where the kid doesn't have access. I just, even I'm thinking in a legal state that's good advice.
Yep.
To
No, it's absolutely, which we'll go into this now unless there are other questions. Yes?
Just a quick answer to your question. One of the things they test the infants for is their meconium, which is a fancy word for infant.
Yeah, that's what
I don't know what you do about that in court.
Right.
I want to go back to the privilege issue. I mean, I understand in the Child Protective Services context, what you say to the doctor could be used, but what about the criminal context? In other words, privilege may not apply the child custody portion, but by practitioners of child abuse, et cetera. I mean, so we still have the argument that it's protected by privilege in the criminal context.
Thing. If it is the child's communication and not the parent's communication, the parent cannot assert the child's privilege on the parent's behalf. But if the child is not a defendant.
But the parent is making, because they're responsible for making the medical decisions on behalf of the minor child, then aren't they really, I mean, they're discussing mechanism of injury. The child can't communicate mechanism of injury. Those are the things that are covered by privilege. So,
doesn't the mandatory reporter take it out of that?
Yes, for criminal and.
I can actually answer that. In the case of child abuse, alleged child abuse, the medical privilege in that situation, it does not exist because the alleged victim is the child. And so there is no privilege there. It's the same thing in a domestic violence case. You know, husband brings wife to emergency room. How did this happen? If he says, you know, we got in a fight and I hit her, that's coming in. And they may not have the same guardianship relationship, but because in a child abuse case, the allegation is child abuse, and the parent is the alleged abuser, the privilege is not.
Yeah, I mean, for 1,000 different reasons, and it's totally creative. It's totally creative. So to go to what is the positive testimony that we can provide, keep it away from the kids. The workforces that worked on this, they want to include in the regulations various things like this that will make sure that all edibles have to be sold in a certain type of packaging. Members of the industry are developing these types of packaging that can be reusable, that you can take back to the store. That hard plastic bag stuff with a zipper that then actually locks. So I mean, there are things that we need to know about and to promote. If you have, something very simple and your children mind you, as they should, marking things with a big red X, a poison symbol, something, and it might be that you consider treating your other prescription medications more carefully as well. Because when I started thinking about this, I started thinking about, well, where do we all keep our bars? They're completely accessible to the kids. And yet, when we think that the kids might be dipping in, we'll move it, we'll mark it, whatever. So these are all very reasonable types of things. Know what the symptoms of a cannabis overdose are. Heavy sedation, sometimes anxiety, heart racing, heavy perspiration, nausea, vomiting. If you need to call 911, you have to. You cannot stand to be accused of failing to, provide needed medical care. Eat something high in sugar, sleep it off. It really does most often wear off, but each parent knows their individual child better. We go into, and I'm going to pass around this brochure that we've created, effects on parenting, both positive and negative. And this is trying to get to the fact that possession or use of marijuana is harmful to the child's environment in terms of making the parent less able to care for the child or to provide adequate care for the child. And so this portion of what we're trying to develop is designed more for mental health workers, to teach parents about this, to teach judges about this, because in the CPS cases and in the family cases, the lawyers really don't get to be the experts on this stuff. And the judges really do not want to be the decision makers in these things. So they have virtually handed over the responsibility for deciding, is the child in danger, is there a harm, to this cadre of mental health professionals. I don't think they're as draconian as the drug endangerment experts that Michael was talking about, and they are reachable in terms of being more open-minded. They've dealt with alcohol, they've dealt with drugs before, they're realistic, and the cases that they see have these issues coming up more and more, and they know the difference between a household that is completely rendered non-functional by a substance abuse, just addicted, ravaged parent, and somebody who uses medical marijuana responsibly or smokes pot when ever they choose to do so without harming themselves or their kids. Yes?
I had a question about the parent who is handing the joint because they're like, I want you to smoke it at home for the first time so you're not out with your friends, about that case.
It is illegal for anyone under 21 to use or possess marijuana. It is illegal for anyone under 18 to use or possess alcohol. So you run a risk in doing so. As parents, it's a completely individualized perception. I might suggest that that's something we wait a little while, or talk about in comfortable company, because having this conversation, have the conversation about pot in front of your kids, about smoking marijuana in front of your kids, in front of your neighbors, in front of the parents that your kids go to school with, this is something that's slow in coming comfortably in the general public. And so we do have to try to be really good ambassadors in this regard. And I'm not saying that that is right or wrong. I think that parents get to the point they get to and they know their kids and what harms them and what doesn't. I'm saying generally that's going to be a hard sell.
I think, it is a very hard sell, but in terms of dealing with especially CSP and those people, they are, in my experience, very receptive to the alcohol analogies. They care a lot about how clean is the house. They care about things that they're looking at in other contexts, and the more that you can point to, open their mind to analogous substances and analogous issues, but a lot of them are at the point where they won't, sometimes they'll defer for 6 months, they'll just get rid of it right away, they'll delete it from their systems, in Colorado at least. When you present those sorts of arguments that show you've educated your child, you've had the conversation, you've done the responsible thing, it may be different than their decision might be, but you have a right as a parent, and they will see that it is not affecting the child's mental or well-being or safety.
You need to also be aware of the possible negative effects on your parenting. Kind of like with alcohol, we have to judge, can we drive our kid to the emergency room if it becomes necessary? Am I going to pass out on the kid and I need to pay attention? So we need to know these things. And, experienced users do know these things, but a lot more people are going to begin to be using marijuana who didn't before, who haven't before, and so it's important to be aware going in of slowing down your cognitive ability. It might impede, your decision-making ability. You can get self-absorbed. Sometimes, again, the mood thing, it can make you, unfocused and less stable. And again, this is something that each individual person needs to know for themselves. So one of the suggestions that one of our members made is, you know, and I hadn't thought about this before, but keeping a diary, especially right now while the products are so varied in terms of effect, keep a journal of, you know, what you take and what it does and how long it lasts. Think about, how do you want to talk about this with your kids? Do you want to smoke in front of them? Do you want to encourage them to try it at home? But for sure, keep everything away from the kids. Make sure that you can drive safely and legally. Talk to Paul. Lenny was also telling me about an interesting iPhone app that that judges impairment. I think it might be in development. So when I've said we throughout this, I have been so fortunate, and I would not have known any of these things without this wonderful group of women so far. And we have named ourselves Cannabis at Home. And so far we are moms, industry people, we have a school counselor, we need to add some mental health people. We have a group, and basically we want to figure out the best way to sustain the conversation among all of the different kind of target groups. And so I can envision at retail stores, at medical marijuana stores, having information available for people who come in about child custody and child issues. Yes?
And I wanted to make a plug for collaborative law in case you haven't heard of that term. It's a team approach to family law conflicts. It's called collaborative divorce, collaborative law. And what that is getting all the people in the room, including these experts, including anybody you felt was a decision maker, and it can help make, you can come to resolution on these complicated cases because you've got everybody that matters in the room, and then you're out of the court system, and it's a much better vehicle, other than it's kind of pricey, for getting to some resolution on these kid issues.
Yeah, and that's a great thing for people who have money.
Yeah.
And there are also the ability to have court-appointed assessors, and they have to be educated as well. So what I want to say in closing is that this social change aspect is one piece of what it is that we can do, especially when we're talking about the state, and especially when we're talking about district attorneys. The first thing we do is we beat them, and then they will stop. So we have to beat them. And until we beat them, we have to just keep after it and grind them down. The way we beat them is, you know, exceptional legal skills, public outcry, the change in public perception, and even in the states where you're not legal, you're gonna get there. I mean, we're gonna get there. And then if it still all fails, let's figure out how to sue them. Thank you.
Since we beat the privilege horse to death, can you just briefly address, having dealt in the system, how do you advise your client? They have an obligation to social services because they want their kids back, and they have to communicate with them and talk to them. Is lawyering up in their best interest? What should they be admitting? What should they be saying to physicians? And to social services about their own use, especially in states where you're not admitting to a crime, but you're admitting to something that could be the basis for a different crime? Mark.
It's Michael, but I think...
Michael, sorry.
Oh, and I want to just give a two-word answer to that.
Okay, go ahead.
It depends.
It does, but I think what I was going to say is that if once the case is in the court system, I know that there are rulings that basically say that what a parent has to say, or anybody involved in the system has to say to be cooperative with the investigation and the development of the case is compelled and is therefore protected by the Fifth Amendment, because it can't be used against you, because it is compelled. So it can't be used generally. It can't be used in a criminal case. For example, a probation interview. You're by law, you're required to cooperate. You have to, or you could be punished more harshly. So that is considered compelled. I think it applies in a child protective or juvenile dependency case, that because the worst thing you can do is fail to cooperate. So your cooperation is compelled, and your statements are immunized. Am I right, Michelle?
Well, at least in Colorado, you actually need a specific court order, because that's not true.
Right.
You get that court order in Colorado, but until you do, it's not complicated.
Right. The point is, and I think for all of us, you need to understand your state's law and think it through, because especially where you preempt either you're part of a group like Michele, or you have clients that you're advising, you run a difficult balance of you're required to cooperate, but by cooperating you've now admitted to a statement against your penal interest, and it's not necessarily privileged or covered in all states unless you exercise your Fifth Amendment privilege. So, I think this is a serious topic that is going to impact a lot of our clients. So, use the collaborative discussion, think it through. It depends, but it's a great answer. But let's discuss amongst ourselves what are the circumstances. Is it when the kid gets test positive?
Laura, would you like to join Cannabis at Home and lead that up?
When I'm done with my next gazillion shots, we'll do a chat and see what.
I wanted to make sure you guys got out on time.
Yeah, we still have
two things. The first
5
is
more minutes.
there's no scientific evidence to support the notion that children get high from secondhand smoke. It comes up repeatedly in legislative hearings, and each time I testify,